My name's Greg Mitchell. I'm the managing partner of AG Climber. Again, our firm is located in downtown Columbus, Ohio. Our phone number is 614-221-3318. And you can check us out on our website, which is www.agclimber.com.
How common is it for workman compensation claims to be denied, and why does it happen?
Yeah, it's fairly common to get denied, and a lot of those denials are easily avoidable and certainly not the injured worker's fault. It's possible that paperwork was filed incorrectly by the employer, or the doctor filled out something wrong, or it wasn't complete. That can lead to confusion and either denial by the Bureau of Workers' Comp if the individual works for a smaller employer. If they work for a larger employer that's self-insured, then the self-insured employer makes the initial decision on the claim, and they can deny the claim for a whole host of reasons, some of which aren't legal. That's why it's so important from our standpoint for any injured worker to seek legal advice.
What's one of the biggest mistakes, or a couple of the biggest mistakes people make when trying to handle even a claim or a denied claim, especially on their own?
Yeah, a lot of times we see that the injured worker just assumes that the employer is going to take care of them. And many times it's not the employer's fault either. In other words, the employers are represented by a third-party administrator, and they're the ones that usually guide the employer of what to do or not to do. And that's, of course, lost with the injured worker. They just all they know is the person they work for, maybe their supervisor or a manager, and they don't understand how a claim could get denied when the third-party administrator may be looking for the appropriate language from the doctor, or maybe some accident report that was sent to them doesn't match up with a different report that the injured worker completed or the doctor completed, and that can lead to, maybe a claim getting denied. So that's why, unfortunately, it happens regularly, and it's not the injured worker's fault. But if a claim gets denied by the Bureau of Workers' Compensation, there's only 14 days to appeal. I've met some workers who just assume, oh, well, clearly that's wrong. It's a mistake. They'll rectify it. And of course, that doesn't happen. Then the claim's barred forever. Or they manage to appeal it themselves, and a hearing gets scheduled, and they either don't show up at the hearing because they don't understand what it could be, or they do show up and have no idea what's going on. And obviously that can lead to a claim getting denied at a hearing stage. So yeah, a lot of things can go sideways pretty quickly, unfortunately.
You had mentioned 14 days to appeal. Can you walk us through what the appeal process actually looks like, and how having an attorney changes sort of some negative outcomes?
Sure. Again, for the smaller employers, if an injured worker works for a smaller employer, that's usually 50 people or less, then it's probably what we call state fund claim, which means the Bureau of Workers' Compensation, that agency actually makes the decisions in the claim. And if they issue an order, either side has 14 days to appeal that order. If either side appeals, that would be either the injured worker or the employer, then the matter gets set for a hearing in front of an industrial commission hearing officer. And that's usually scheduled roughly about a month after the order comes out and is appealed. And that's where a hearing officer, who is a lawyer but not a judge, he's a lawyer to basically settle the dispute, whatever it might be, relative to did the injury actually happen, or if the injury did happen, what are the specific medical conditions that are a result of that injury? Because sometimes, oftentimes actually, there can be a dispute of exactly what the extent of that injury is. And that's what the hearing officer's job is. And also to determine if the injured worker missed time from work after the injury, is he or she entitled to compensation? So those are just a few of the issues that the hearing officer would have to decide. The first level hearing is called a district level hearing. And once that decision is issued from the district hearing officer, once again, each side has 14 days to appeal that decision, and another hearing will be scheduled roughly 4 to 6 weeks later in front of a staff hearing officer. He's also with the industrial commission, but has typically more experience than the district hearing officer, so another hearing takes place. So if you follow that through, that can lead to a lot of frustration for the injured worker, because if you have to go through the original order and 2 hearings, many times we're talking about 3 to 4 months after the date of injury before there's a final hearing to actually get a final decision on just the claim being recognized. So that can be a difficult process. Getting an attorney involved helps because, first of all, we wouldn't know whether or not an order needs to be appealed or not. If not, explain to the injured worker why it's favorable to them and everything should be fine. And if not, appeal it as quickly as possible and try to get that hearing as quickly as possible so we can get this claim recognized officially and get medical bills paid and get compensation for the injured worker.
What are some of the key things that you look for when working up your appeal?
Well, one thing certainly, if they're able to, of course, we usually don't talk to them before, but to document not only what happened at the injury, but who they told. Did they tell a supervisor or manager or another coworker? They make sure you know their names. That can help in case there's some sort of dispute about the injury itself or exactly what happened. That's important. Certainly to seek medical treatment as soon as possible, even if you think you're not that injured or it'll just go away. The best thing you can do is go to an emergency room or urgent care to at least get checked out, have a written record then of what you are concerned about or what may be giving you a problem at that particular point in time. Those are, I would say, two of the big ones. And then certainly if you get, our position is if you get anything in writing from the BWC, your employer or your employer's third-party representative, and it's not extremely clear to you to contact an attorney to go over that letter or order you may have received and learn about all your rights.
When you're negotiating and representing yourselves, there's a lot of pitfalls because you don't do it every day. Your firm does it every day. So how does having an attorney change the dynamic when negotiating with insurance company and the BWC?
Well, our firm especially has been around a long time. We've been around in one way, shape, or form since the 1940s. So we have a wealth of experience. Sometimes there are, unfortunately, sort of tricks that some of the employers can employ, frankly, whether it's delaying making a decision on something or giving them incorrect information, making them sound like they can't see a doctor, or giving them the impression that if they do get treatment that they could be terminated. Things like that happen all the time, and that's where we come in and can explain all of their rights, set them at ease, hopefully, about what can happen in their claim, what should happen, and make sure that the employer is not trying something that's not appropriate under the rules and regulations. And, unfortunately, even for those claims that are with smaller employers, sometimes BWC claims representatives can just make a mistake or not see something, and obviously we help make sure those types of mistakes don't happen or correct them if they do.
It sounds like you have a very technical aspect to the procedural, but sometimes negotiations don't work. Does your firm fight for clients in hearings?
Yeah, that's what's somewhat unique of our firm, maybe compared to others, is we cover a claim from beginning to end. Sometimes disputes aren't resolved completely even after the Industrial Commission hearings. So the last step in an appeal process is either party can appeal a denied medical condition, for example, into the common pleas court system. A lot of firms that represent injured workers, if that happens, they just get out of the claim. Tell the injured worker that there's nothing else they can do, or they provide them a name or two of some other attorney somewhere else that might take their case. We don't do that. We continue to represent our injured workers even if the claim gets filed into the common pleas court system, and either resolve it or, if necessary, go all the way to a trial. That's, I think, what's unique about our firm is we won't abandon our injured workers. We're with them.
Do you have a particular success story where your firm helped turn a denied claim into a positive outcome to give us all hope?
Pleased to say we've represented thousands of injured workers of all different genders, races, creeds. Sometimes those are the most challenging if you have some workers that aren't that proficient in English to be able to assist them. Thankfully we have for example, Spanish interpreter here that works in the office, and that's been very beneficial for some of our Spanish-speaking clients. So there's a broad range. It's hard for me to pinpoint one, but it's always nice if we can obtain certain awards. There's permanent total disability is for those significant injuries that prevent an injured worker's ability to return to the workforce in any capacity. Those are typically our bigger cases, and certainly when those types of claims are given through, we see a lot of relief and thankfulness from our clients. That's for sure. In fact, I've got one tomorrow morning that I'm confident we're going to be successful in for a lady that's been through a lot, and I'm looking forward to getting a favorable decision and putting her mind finally at ease after several years of suffering.
Is there one piece of advice you'd like to give to any workers out there struggling with a compensation claim right now?
Well, if they don't have an attorney, the biggest piece of advice is to get an attorney involved. Our firm and other firms that represent injured workers, we, to my knowledge, all have the same type of fee contract, which is called a contingent fee contract, which means we only get attorney fees if we obtain benefits for the injured worker. So I think a lot of people maybe don't call an attorney because they feel like as soon as they pick up the phone and talk to someone, they're going to get a bill in the mail, and that's not how it works. So hopefully that's not a reason someone's not reaching out to an attorney, because there are no attorney fees unless we get benefits for them. And that's the only way they're going to know all of the rights under the workers' comp system, is to speak to an attorney. For those that may be represented and are still confused or upset, then I would say two things. Number one, schedule a specific phone or office conference with the attorney assigned to your claim, whatever firm it might be, and ask them direct questions, or make them sit down with you in a specific period of time to answer all your questions or concerns, and hopefully make you feel better about things. If they don't do that or not to your satisfaction, understand you do have the ability to terminate their services and hire a different attorney. You have every right to do that. You're not bound just because you signed an initial contract with somebody. You have the right to terminate their services and seek an opinion elsewhere. Unfortunately, we have helped out many clients who didn't have a great experience with, for whatever reason, with their initial attorney, and we've been able to assist them after, of course, they've terminated the services with their initial attorney. You need to get legal advice. Understand all employers have legal representation, and they're getting legal advice when someone gets hurt, so why shouldn't you? And you just want to try to keep the playing field level. At least know all your rights. And if you talk to an attorney and you feel like, well, they're not going to offer me much more than I think I can handle on myself, then that's the injured worker's choice. And I'm sure there's some success stories out there. At least you would know your rights from someone that practices in this area every day, so you can make a reasoned choice.
Talking to you out of Columbus, Ohio right now, but you have offices across Central Ohio. Do you want to give us just a short rundown of that and how people can get a hold of you?
Sure. Well, our main office is here in Columbus, Ohio, which is helpful. We're literally just a few blocks from both the Bureau of Workers' Compensation and the Industrial Commission of Ohio, where hearings are held. There are other Industrial Commission offices around the state that hold hearings as well, and we assist injured workers all over the state. Many hearings we can now do telephonically, but we can also travel if need be. We have an office, physical office in Jackson, Ohio, and we also have basically office share agreements with other attorneys in Chillicothe, Ohio, and Gallaudet, Ohio. So we kind of cover mid-central down all the way to the Ohio River, but we also represent clients from every corner of the state, from Toledo to Cleveland to Youngstown, Dayton, Cincinnati, all the major areas. We have clients in every major area, and many, many rural areas as well. So thankfully, we have enough attorneys and enough staff to be able to handle claims all over the state. So we're kind of the best place, in our opinion, to call, because we can handle it.
Excellent. It sounds like a well-oiled machine there. Just as a bonus question here, we recently were on a call, and I was throwing some jargon around of what I do, digital marketing and whatnot, and I was throwing around SEO, PPC, CRO, and other acronyms that sort of put a smile to your face. I wanted to let you know that I was equally confused, dismayed, intrigued by TPD, TTD, PPD, PTD. And could you, in the last closing minutes, just go down those acronyms for me? And I'd appreciate it.
Yeah, sure. Yeah, we do live in an acronym-heavy world sometimes. I guess the first acronym I put out is FROI, or as I like to pronounce it, the FWA. That stands for First Report of Injury, and that's typically the initial form that an injured worker completes when they get injured. After the injury is filed, we're We're hoping to get them TTD, which is temporary total disability. That benefits when you're completely off of work because of the injury. PPD is permanent partial disability. The closest analogy to that is pain and suffering. It's something we can apply for 6 months after the injury or 6 months after an injured worker returns to work following an injury. And it's to try to get some compensation for the individual that's still having some lingering effects, even though they've returned to work. PTD is permanent total disability, and that's for those severe injuries where an individual is found unable to not only go back to their normal job, but unable to work at all anymore for the rest of their life because of the combination of their injuries. And if permanent total disability is granted, the individual does get paid for the rest of their life. So that hits some of the highlights of some of the acronyms.
It's good to have a person that can navigate you through the changes when you're experiencing something so stressful, and so because everything seems to have a deadline, everything seems to have a filing requirement, and
Right.
so having a trusted advisor is worth its weight in gold in peace of mind. And I just appreciate you taking the time to help us understand.
Thanks. Yeah, appreciate your time, Mark, and I hope people that need to see this message and get information see it. If you'd like our help, we'd love to help you out. My name's Greg Mitchell. I'm the managing partner of AG Climber. Again, our firm is located in downtown Columbus, Ohio. Our phone number is 614-221-3318, and you can check us out on our website, which is www.agclimber.com. You don't have to live in pain or worry about losing your job. If you believe your work has caused or aggravated an injury, AG Climber, Mitchell and Portman can help you fight for your rights. Call us today for a free case review at 614-221-3318 or visit us online at agclimber.com. Thank you for watching.